All right, welcome back everyone to our water fluoridation investigation. So today I thought we would wrap up our cease and desist. But before we jump into that, I want to cover something that has come up a few times now. And that is that the people that want to contaminate our drinking water with the chemical drug hydrofluorosilicic acid says that the same type of fluoride ion that's in hydrofluorosilicic acid is the same type of fluoride ion that is in naturally occurring calcium fluoride. That is true, but they are very different things. And let me explain what I mean. So I've got my calcium fluoride over here in my handy dandy box. And let me go ahead and line it up and show you. So this is naturally occurring calcium fluoride. I can hold it in my hand. It's very safe, right? Nothing's gonna happen, right? In this calcium fluoride, there is a fluoride ion. That is true. Now, the same type of fluoride ion that is in calcium fluoride is in fact the same type of fluoride ion that is in hydrofluorosilicic acid. But the difference between the two is I can hold calcium fluoride in my hands and I will be fine. If I were to hold hydrofluorosilicic acid in my hand, it would actually eat away at my hand, okay? It is a very acidic product and it would eat straight through my skin, it would eat straight through my bones, and I would not have a hand left. So, if you were to hear that, don't worry, it's the same type of fluoride ion, say yes, but you can hold calcium fluoride in your hand. You cannot hold hydrofluorosilicic acid in your hand, and that is the distinction. So I thought I would show you just really quickly where this is on the periodic table. So we did discuss fluoride in anatomy and physiology, and we discussed how deadly how deadly fluoride is, okay, to the human body. Remember, it will make animals permanently go to sleep, which is why they spray it on the crops in order to get rid of undesirable bugs and animals. Now, we also discussed fluoride, types of fluoride, in microbiology. And in that class, we learned how dangerous fluoride is to the human body and the organisms. Then we actually covered fluoride a little bit in statistics, where we learned how pro-fluoride folks manipulate data in order to push a particular agenda. Great book, by the way, guys. Elemental Statistics. You can pretty much read that book and you don't need to keep going. It's so fabulous. Now, we also covered this topic in organic chemistry, where again we learned how fluoride will destroy life. Okay? But let's go all the way back to the very first semester of basic chemistry. And if you open up the book, usually in the very beginning, you have the periodic table. And hopefully I can show you this. We have it's upside down. We have over here, we have the halogen group, and we have fluorine, right? Fluorine is the most reactive halogen of all of the halogens. It wants to bind to everything. It binds to the calcium in your teeth. it binds to the calcium in your bones, it binds to the calcium in your brain, and it will interfere with calcium channels. So this is a very, very dangerous and reactive element on the periodic table. So I hope that helps you. You know, they try to kind of throw you off and make you feel less than when you say that you do not want a recycled hazardous waste byproduct in the water. They will laugh at you and say, "Oh, you silly girl, a fluoride ion is a fluoride ion. This fluoride ion is the same as this fluoride ion." That is true, but remember, again, I can hold this calcium fluoride in my hands. I cannot hold hydrofluorosilicic acid in my hands because I wouldn't have a hand left, and that is the distinction. So the fact that the pro-fluoride groups are hell-bent on using these linguistic games shows how dirty they are, right? Shows how slimy they are. So the next time somebody tells you, "Oh, a fluoride ion is a fluoride ion is a fluoride ion," you can go tell them to go pound sand, and that you cannot hold hydrofluorosilicic acid in your bare hands, but you can hold calcium fluoride in your bare hands. So cut it out and maybe just stop being so evil. Okay, so now let's get into our cease and desist. This is going to be our final video on this topic. Okay, guys, so here we go. Let's get into it. Okay, guys, so we left off on unlawful expenditure of taxpayer funds. Henrico County is using public funds to support an unauthorized program by adding fluoride to the water supply without lawful authority. The expenditure of taxpayer money on this activity is unlawful and constitutes a misuse of public resources, as no statute, ordinance, or legal authorization permits the county to fund or implement water fluoridation. That is what I am alleging, folks. That is the controversy. I go on to say, continuing to allocate funds in this manner not only violates Dillon's rule, but also exposes the county to potential civil liability for the unlawful appropriation of taxpayer resources. Public funds should be directed towards legitimate authorized programs that serve the actual public interest, not an unlawful and harmful practice lacking statutory or public health justification. Under Virginia law, Henrico County cannot spend taxpayer money on a program it has no legal authority to fund. Right, guys? The Board of Supervisors can't just spend taxpayer money on whatever they feel like it. They can't spend taxpayer money on their vacation or to build the Eiffel Tower or anything else, to put up little statues of dogs all over Henrico. You cannot just spend whatever you feel like it. It has to be lawful. You have to spend money in a lawful way. Contrary to what's actually taking place in the government. That's what's supposed to happen, folks. I feel like taxation is theft, in my opinion, but that's a different topic for a different day. This is not just a policy argument. It is a legal requirement. It is a legal requirement that you spend money in a legal manner. I keep asking Henrico for a year and a half, what authorizes you to spend taxpayer money on this fluoride program? They have never once responded back in a legitimate fashion. One time they responded back by saying, "Well, we operate a waterworks. So because we have a waterworks, we can do whatever we want," essentially. All right, number one, no statutory authority. 32.1-170 of the Code of Virginia empowers the Board of Health to regulate waterworks and water quality to ensure pure water. This statute is limited to removing contaminants and ensuring safe drinking water. It does not authorize Henrico to fluoridate the water. Under the Dillon Rule, local governments like Henrico County only have powers that are expressly granted, necessarily implied, or essential. We covered that earlier. Fluoridation meets none of these standards. Remember, fluoride, there is no law that expressly grants Henrico to put fluoride in the drinking water. There is no law in Virginia that says that fluoride is necessarily implied in such law. And fluoride is not essential to promote pure water. It is not used to make the water safe to drink. It is used as medicine. It is used to medicate the public. No ordinance, no local ordinance. Henrico County has not enacted any ordinance authorizing fluoridation. Now, because the law doesn't allow them to put fluoride in the drinking water, even if they passed an ordinance tomorrow, it would not magically make it lawful. It makes it that much worse that they don't have an ordinance. Okay, they did not even attempt to do this on the up and up. Public funds cannot legally be spent on activities lacking both statutory and local legislative authority. Guys, we in America, you have to follow the law regarding spending, okay? You have to have the statutory authority to spend money. Virginia criminal statutes. Virginia law makes it a crime for public officials to misuse funds or public assets. 18.2-112, embezzlement by public officers. So this is the question. The judge will have to determine whether or not Henrico has the legal authority to spend taxpayer money. And if the judge finds that they don't have the authority to spend taxpayer money, then it is a possibility that they are violating 18.2-112, 18.2-112.1, and so forth. Okay, so that's the controversy. This is what the code says. If any officer, agent, or employee of the Commonwealth or of any political subdivision knowingly misuses or disposes of public funds otherwise than in accordance with law, he shall be guilty of a class 4 felony. Now, I've pointed out, you don't have the legal authority to do this, right? I've provided the information and they continue to do it. So right now they're knowingly spending the money and they cannot cite a law. So you can't spend money unless the law allows you to spend the money. 18.2-112.1, misuse of public assets. Any full-time officer, agent, or employee of a county who, without lawful authorization, uses or permits the use of public assets for purposes unrelated to legitimate government duties is guilty of a class 4 felony if the value exceeds $1,000 in a 12-month period. So adding hydrofluorosilicic acid to the public drinking water, is that a legitimate government duty? That is the controversy, and that is what the judge will have to determine. Is this, in fact, a legitimate duty? Henrico does not have any documents for the purpose of water fluoridation. They do not have any documents for the justification to put the chemical drug in the drinking water. They do not have documents to support the safety. They do not have an ordinance. They cannot point to a state law. A federal judge says this poses an unreasonable risk of injury. The FDA has barred doctors from prescribing fluoride for children under the age of 3. So how could you possibly imagine that this fluoride program constitutes a legitimate government duty. I don't think it is, right? That is my opinion, okay? So this is what is being alleged. Application to Henrico. Henrico County has no statutory authorization for fluoridation. Henrico County has no ordinance authorizing expenditures for fluoridation, yet taxpayer funds are being used to support the program. Now, just so you know, this cease and desist that I sent to Henrico, I'm asking them to please clarify if I am mistaken and you are allowed to have this fluoride program, please correct the record. For a year and a half, they have not corrected the record and pointed to any law that authorizes them to do it. With this cease and desist, I said, please answer these questions. If you cannot, I will escalate the matter and have a judge figure this out for you. So I've given them ample opportunity to correct the record if I'm mistaken. So my claims are done in good faith, okay? If these expenditures were made knowingly, the actions could satisfy the criminal elements under 18.2-112, 18.2-112.1, specifically misusing public funds otherwise in accordance with the law. So they will have to point to a law that authorizes them to spend our money on chemical drugs that go into the drinking water and using public assets without lawful authorization. And it can't be arbitrary and capricious. I would say when you don't have any records for the purpose, justification, or safety, I would say that constitutes as arbitrary and capricious. Conclusion. Henrico County must immediately cease the expenditure of taxpayer funds on the fluoridation program. Continuing this program in the absence of clear statutory or local authority violates Dillon's Rule and 15.2-950 of the Code of Virginia governing lawful appropriations and may expose responsible officials to potential liability under Virginia law. So potentially this could be a problem for them. This is the controversy, folks. Henrico County has been placed on notice on multiple occasions that no clear statutory authority exists for the fluoridation program or the associated expenditure of public funds. Despite this, the county has continued to fund and implement the program. Continued action in the face of repeated notice cannot be characterized as inadvertent. Rather, it constitutes knowing and willful ultra vires conduct in disregard of established legal limitations on the county's authority. Guys, if they are, this is a fact, they are putting a chemical drug in the drinking water. This is an FDA-defined chemical drug. It is extremely egregious for them to be putting a chemical drug in the drinking water, and they cannot say that this is lawful. They cannot point to the authority. They cannot explain themselves. How do you get away with this? How is it that in Virginia, people are actively putting chemical drugs in the drinking water, and then they say for a year and a half, well, we're still trying to figure out who's in charge. We're still trying to figure out, why we're allowed to do this. This is just so egregious. The continued expenditure of public funds under these circumstances reflects a deliberate and knowing disregard for the constraints imposed by Virginia law, including Dillon's Rule. So the action required, this is what I sent to them. Halt all fluoridation expenditures immediately. Repeal or rescind any administrative recommendations or programs that lack legal authority. Align all further public spending and statutory and local ordinance authority. Okay. References. Line all future public spending with statutory and local ordinance authority. That's never going to happen because there is no statutory authority, which means that they can't do any ordinance. Just so you guys are up to date on that. All right, here's the references. You guys can go and read the law. Well, I don't know. Maybe I will go ahead and read it for you. So it says 18.2-112, embezzlement by officers, etc., of public or other funds, default in paying or paying over funds, evidence of guilt. So this is what the law says. It says, any officer, agent, or employee of the Commonwealth or of any city, town, county, or any other political subdivision, or the deputy of any such officer having custody of public funds or other funds coming into the custody under his official capacity, knowingly misuse or misappropriate the same or knowingly dispose thereof otherwise than in accordance with law. That's the kicker. It's got to be accordance with law. He shall be guilty of a class 4 felony, and any default of such officer, agent, employee, or deputy in paying over any such funds to the proper authority when required by law to do so shall be deemed prima facie evidence of his guilt. The next one, 18.2-112.1, misuse of public assets penalty. It says here, for purposes of this section, public assets means personal property belonging to or paid for by the Commonwealth or any city, town, county, or other political subdivision, or the labor of any person other than the accused that is paid for by the Commonwealth or any city, town, county, or other political subdivision. Any full-time officer, agent, or employee of the Commonwealth or of any city, town, county, or any other political subdivision who, without lawful authorization, that's the controversy, does Henrico have the legal authority to put chemical drugs in the drinking water where they do not have the purpose, justification, or safety. Uses or permits the use of public assets for private or personal purposes unrelated to the duty. So the fact that Henrico, the DPU director, remember, this is being done on an administrative level. So the county manager and the DPU director, they're deciding to put this chemical drug in the drinking water because that's what they feel like. That's what they want to do. So to me, it would seem like they're doing this for personal reasons. I mean, I guess that's what the court will have to figure out. You know, you don't have the law backing you. So it would seem that you're doing this because you personally feel like you want to drug the public. So uses or permits the use of public assets for private or personal purposes unrelated to the duties and office of the accused or any other legitimate government interest when the value of such use exceeds $1,000 in any 12-month period is guilty of a class 4 felony. So to put fluoride in the drinking water, I am arguing that it's unrelated to the duties of the office. It's unrelated to the duties of providing pure water. Everyone involved, from the waterworks operators all the way up to the board of supervisors, to me I would imagine it's going to be a problem for all of them. But that's what the judge will figure it out. Any county, city, or town shall be permitted to adopt a local ordinance that provides that any non-full-time officer, agent, employee, or elected official of the county, city, or town who, without lawful authorization, there we go. I've asked for a year and a half. What law authorizes you to put this chemical drug in the drinking water? they will not cite anything. For a year and a half, they say, we don't have the statutory authority. We don't have a police power that this promotes public health. So I have no choice but to believe that they do not have the lawful authority. If you've asked for a year and a half, several times a week, for a year, what law authorizes you to put hydrofluorosilicic acid into the drinking water, and they don't respond back? It kind of seems like they don't actually have the lawful authority. I don't know how else to see it. I've asked them in person. I've done the speeches, emails, you name it. I have reached out, and they cannot cite the lawful authority. Even when I sent the cease and desist, they didn't respond back with any law citing legal authorization. So, I don't know how else to see it, folks. All right, we have Code of Virginia 15.2-950, appropriations. And it says a locality may make appropriations for the purposes for which it is empowered to levy taxes and make assessments for the support of the locality, for the performance of its functions, and the accomplishment of all other lawful purposes and objections subject to such limitations as may be imposed by law. All right, so these were my demands. Accordingly, you are hereby demanded to 1. Immediately cease the county's unlawful fluoridation of the public drinking water supply, or provide within 10 days of receipt of this letter the following. The specific Virginia statutes granting Henrico County authority to fluoridate the drinking water. Do you think they responded back with a Virginia statute? No. Any duly enacted county ordinance authorizing such action. They don't have an ordinance. They say repeatedly they don't have an ordinance, but you have to put it in the cease and desist for the record, for the judge. All records identifying the legal and ethical basis relied upon by the county to justify fluoridation under Virginia law. They do not have any records identifying the legal and ethical basis relied upon by the county to justify fluoridation under Virginia law. They did not respond with anything whatsoever. I try to work this out. Henrico County is engaging in ultra-virus conduct by adding fluoride without lawful authority. The unauthorized action is invalid, unlawful, and exposes the county to legal liability, including claims arising from the misuse of taxpayer funds and ongoing harm to residents. Failure to comply with this demand will leave me no choice but to pursue all available legal remedies, including but not limited to seeking injunctive relief in a court of competent jurisdiction to prevent the continued unauthorized exercise of government power and unlawful expenditure of taxpayer funds and the ongoing exposure of residents to a harmful substance. Remember, this is a poison that they are actively putting in the drinking water. They do not say they have a purpose for putting the poison in the water. They do not say that they have justification for putting the poison in the drinking water. And they do not say that they have any documents that it's safe for anybody to ingest small amounts of this poison in the public drinking water. Hydrofluorosilicic acid is a poison even when you put a small amount in the water. This unauthorized action exposes the county to legal liability and it must cease immediately. That is what I am saying. Reservation of rights. This letter is written in good faith in an effort to resolve this matter without litigation. Nothing herein shall be deemed a waiver of any rights or remedies available to me, all of which are expressly reserved. All right. Summary. The Virginia Department of Health derives its authority from two places: the Virginia General Assembly and the Safe Drinking Water Act. The Virginia Department of Health derives its authority solely from statutes enacted by the Virginia General Assembly and, where applicable, and from property delegated federal authority and properly delegated authority. Properly delegated federal authority, the EPA, under the Safe Drinking Water Act. Sorry about that, guys. It is a fundamental principle of administrative law that an agency possesses only those powers that are expressly granted by statute, necessarily implied from those express powers, or indispensable to the agency's statutory purpose. Any action taken beyond those limits is ultra vires and void. No provision of Virginia law grants VDH the authority to promulgate regulations that require, approve, or recommend the addition of fluoride to public drinking water for preventive health care purposes. Virginia Department of Health has cited 32.1-112 and 32.1-170 of the Code of Virginia as the basis for its position to recommend water fluoridation under 12 VAC 5-590-930 fluoridation. However, a plain reading of those statutes demonstrates that they authorize the regulation of water quality, safety testing, and distribution to ensure the provision of safe drinking water. They do not authorize the affirmative addition of substances such as fluoride, hydrofluorosilicic acid, to water for the purpose of providing preventive health care to the population. Remember, fluoride makes your teeth harder, makes them more brittle, makes your bones harder, makes your bones more brittle, slows down your thyroid, bioaccumulates in your brain and body, inflames your brain, and there's a significant amount of evidence showing that it harms your brain, similar to lead. Section 32.1-170 directs that regulations governing waterworks be designed to protect the public health and promote the public welfare, and to ensure a supply of pure water. The statutory framework focuses on maintaining water quality by establishing standards, monitoring contaminants, and ensuring safe delivery systems. Nothing in the statute expressly or impliedly authorizes VDH to promote or recommend the addition of substances such as the FDA-defined drug fluoride, or in this case, we're specifically discussing hydrofluorosilicic acid, to drinking water for preventive health care purposes. An agency's interpretation of a statute must conform to the statute's text and structure. It may not expand its authority by relying on generalized public health language to justify actions not contemplated by the legislature. Henrico County and VDH's reliance on 12 VAC 5-590, which states that the board recommends that all community waterworks in Virginia be optimally fluoridated, does not cure this defect. An administrative regulation or recommendation cannot create authority where none exists in the underlying statute. A recommendation, by definition, is not itself, A recommendation, by definition, is not self-executing and carries no independent legal force unless it is grounded in valid statutory authority. Here, no such authority exists. Accordingly, the fluoridation recommendation is not a lawful exercise of delegated power, but instead constitutes an ultra vires act. Moreover, the Safe Drinking Water Act authorizes the U.S. Environmental Protection Agency to establish national drinking water standards designed to protect public health by limiting contaminants in drinking water. The Safe Drinking Water Act provides that no national primary drinking water regulation may require the addition of any substance to drinking water for preventive healthcare purposes unrelated to contamination. This includes fluoride. Therefore, the EPA has stated that it does not require nor recommend the addition of fluoride to drinking water, and that such decisions are made at the state or local level. In other words, the EPA says you can put chlorine in the water to make the water safe to drink, but you cannot put fluoride in the drinking water to medicate the public. The federal government is forbidden from doing that. And when VDH is wearing their little primacy hat, they can't do it either. And the question is, can VDH require Henrico to put fluoride in the drinking water under their responsibilities that the Virginia legislature has granted? That is the controversy. The Safe Drinking Water Act also requires safe drinking water. Safe Drinking Water Act also requires safe drinking water. Therefore, it is both illogical and unreasonable for Henrico County to go out of their way to purchase a well-established toxin such as hydrofluorosilicic acid, fluoride, and intentionally add it to the water. This is absurd, folks. Absolutely absurd. Henrico County Board of Supervisors and county manager cannot legally give multivitamins to the public, but they can put this chemical drug in the drinking water. It's absolutely ludicrous. A federal judge ruled in 2024 that water fluoridation poses an unreasonable risk of injury. Adding fluoride to the water supply would be similar to the county going out of your way to purchase lead, arsenic, or mercury and deliberately adding it to the water. This is preposterous action. I should say this is a preposterous action by the county that is endangering the health of the public. Because the EPA itself lacks authority to mandate or recommend fluoridation under the Safe Drinking Water Act, it cannot delegate such authority to VDH. Nor has VDH claimed that its fluoridation recommendation, see, on one hand, they recommend it under 12 VAC 5-590-930, but in another section, they say if you're going to discontinue water fluoridation, you have to alert the VDH 90 days prior. Well, prior to discontinuing, that means that VDH is forcing a locality to keep the drinking water, to keep fluoride in the drinking water for 90 days. They can't. I don't believe that they can legally do this. Based on reading the meeting minutes, I don't think they can legally do this. So we'll have a judge figure it out. Recommendation, let's see, let me start over. Nor has VDH claimed that its fluoridation recommendation is pursuant to its role as a primacy agency under federal law. In other words, this recommendation that they're making, they're not saying they have the authority to recommend it under the Federal Safe Drinking Water Act as their primacy role. They're claiming they can recommend it under the Virginia General Assembly. Henrico County and VDH's interpretation for authority to fluoridate the water effectively collapses when one analyzes this distinction between advisory guidance and binding legal authority. An ill-advised recommendation cannot supply what the General Assembly has not enacted. Silence in a statutory scheme, particularly one as comprehensive as Virginia's drinking water laws, does not constitute a grant of authority. The decision to authorize the addition of substances to public drinking water for preventive health care purposes is a matter of legislative policy reserved exclusively to the General Assembly. Now, of course, I believe that it's unconstitutional to coerce the public into taking drugs, but, that's just me. The reliance of localities such as Henrico County on VDH's recommendation to fluoridate drinking water does not magically validate the action. Under the Dillon Rule, local governments in Virginia may exercise only those powers expressly granted by the legislature or necessarily implied therefrom. They may not rely on non-binding agency recommendations as a substitute for statutory authority, particularly where such reliance results in the expenditure of public funds or the implementation of programs affecting the public at large. Accordingly, because no Virginia statute authorizes fluoridation and no federal law provides such authority, VDH's recommendation and Henrico's fluoride program exceeds the scope of its lawful powers. Any local action taken in reliance on that recommendation is likewise without legal foundation and must be declared unlawful. If the county cannot demonstrate that its fluoridation program is a valid public health measure authorized by law, then I will have no choice but to seek declaratory and injunctive relief from the court. And that is it, folks. All right, everyone, that is it for today on our cease and desist. I hope that you found it interesting. It took a lot of work in order to put everything together, and I can't wait to hear back on what Henrico has to say, because I've asked them, show me the law, and they cannot point to any law. So I would say a reasonable person may come to the conclusion that perhaps this is an unlawful water fluoridation program. Remember, ingesting small amounts of a poison such as hydrofluorosilicic acid is, in my opinion, arbitrary and capricious, right? Why does the government have the legal authority to compel you to ingest small amounts of a chemical drug, but they, can't compel you to ingest a multivitamin? Yeah, it's because, folks, this isn't about health. It's about protecting the chemical industry. They know if we are successful at getting rid of this chemical drug in the drinking water, then what are we going to come for next? All right, guys, thanks for tuning in. If you like the video, give a thumbs up. Make sure to leave a comment below and share this with others, okay? See you next time. Thanks, guys.